Good morning, everyone. Let me first thank the EPIP organizers 2016 and Graeme in particular to have invited us to contribute to this august conference. I'm not going to make a joke about the bureaucrats' ability to be controversial and original. Anybody who invites an official of an international organization secretariat knows what they're letting themselves in for. So don't expect particularly hair-raising theses from me. I'm going to make some personal remarks and observations about challenges surrounding conclusion of IP agreements. And for the record, they are, of course, not necessarily the view of the WTO Secretariat nor its member states. So in thinking about challenges surrounding IP agreements, I think it's useful to look at the different constellations in which members and countries actually negotiate IP agreements, because I think they render some interesting insights about the forum, the motivation, and the negotiating constraints that countries find themselves and negotiating parties find themselves when they look at concluding treaties. Now, if you look maybe at the one end of the spectrum, the least controversial, the easiest probably is a country joining an existing international treaty. If you look, for instance, at the success of the Hague Agreement or the Madrid Agreement in recent years, that's a relatively straightforward process. It's mostly a domestic consideration of a country. You're entering an existing international system which has, to some extent, proven that it's working. It adds value to your own right holders in projecting their IP rights into other markets. The forum for this undertaking is mostly domestic. It's usually your own parliament, it's your stakeholders, and it is there are very little constraints in exceeding this because the terms of these agreements are relatively clear. Now, it's quite different if, of course, you are negotiating those international treaties, let's say, in the context of WIPO. Now, here, initiatives to conclude international IP agreements are usually the result of decade-long, very meticulous preparation in the different committees of the World Intellectual Property Organization. If you look at the SET or the Standing Committee on Patents, or the Lisbon Agreement, for that matter, that is the result of a number of years of incremental building of consensus, of identifying the issues. And here the motivation structure is quite different. It usually results from a long-standing position of an individual country on the merits of harmonization of that particular question, the building up of a new registration system or the extension of an existing registration system. The forum is, in that case, of course, also very different. It's determined by the negotiating culture of WIPO in that case. And anybody who has followed the negotiation of the Geneva Act of the Lisbon Agreement has probably followed the rather controversial discussion of what exactly those participatory rules in the negotiating forum in WIPO can be. If you recall, the question of whether the new act of the Lisbon Agreement was a treaty that should be open to voting to all WIPO members, not just the members of the existing Lisbon Agreement, but also those who were part of WIPO, was a very controversial issue and led to, I think, reverberations which WIPO is still now feeling in its budget committee and in the scrutiny that the financing of the different treaties internally is concerned with. So, well, on a purely legal and procedural approach, the terms, of course, of the negotiation in WIPO committees is self-determined. There are rules on voting in the different unions. The agreement on holding a diplomatic conference can set the voting rules depending on individual diplomatic conferences. So here, the forum determines some of the rules under which you negotiate. There's a certain degree of transparency or participation by non-negotiating parties predetermined. WIPO obviously has quite a vibrant NGO culture and participatory culture in most of its committees, which usually do the preparatory work, and it has a culture of letting those also participate in the diplomatic conferences. So the constraints in these areas are, if you look from a topic perspective, clearly more developed than on a purely national basis, but they remain usually issue-driven. So if you have a treaty that concerns an extended registration system for geographical indications and appellations of origin, then the constraints concern this issue, the single-issue agreements, the Marrakesh Agreement on VIPs, or the Beijing Audiovisual Treaty, quite focused in that respect. Another aspect of the WIPO forum is, of course, that there is no dispute settlement mechanism attached to these treaties. None of these treaties have particular provisions in that respect. They are theoretically subject, as you know, to adjudication by the International Court of Justice, but this route has never been taken. Now, if you contrast that, for instance, to joining the TRIPS agreement, that is quite a different kettle of fish in terms of motivation, forum, and negotiating constraints. Because joining the TRIPS agreement obviously means joining the World Trade Organization, and decisions to join the World Trade Organization are not uniquely or even predominantly done on the basis of concerns for intellectual property protection. So here already the motivation is usually a general desire to join the multilateral trading system, signal long-term commitment to rule-based multilateral trading regime, and hopefully reap the benefits that this system can produce in the short term and or in the long term. The forum for joining the WTO is, as you may know, quite conspicuously what is called a working party for accession, because joining the WTO takes place on self-defined terms. If you look at the Marrakesh Treaty that is the basis of the WTO. So that means that joining the WTO and joining the TRIPS agreement means you have to conclude agreements with all the existing members. And this defines the terms on which you become a WTO and a TRIPS member. These terms can, and very often do, modify the obligations that you will have under the TRIPS agreement. So if you look at the accession protocols of the number of members over the last decade or 2 decades, you will find a number of recurrent additional commitments that members take when they join the WTO, including obligations to join other treaties, including obligations to sometimes take on TRIPS plus obligations in their national law. So the motivation to join, as I said, the motivation is obviously not confined to intellectual property, but that means, of course, that the negotiation constraints that a party faces when it joins the WTO, and let's say their considerations for the IP commitments that it is willing to take, are quite different. So you're not, like in WIPO, a single issue consideration where you have a team of IP negotiators that consider which type of registration system will be the best for your appellations of origin. You are in a mix of objectives where concerns for market access, for services commitments, or for other regulatory commitments you might take in other parts of the WTO may very well trump the concerns that the IP part of your negotiations may have, and they may be traded off according to the preference of your particular government and the rating that is given to the IP concerns in that mix of objectives. Now, different from that is, of course, negotiating IP within the WTO, and there you know that the negotiating system of the WTO is what is called the single undertaking system. The idea and the model of negotiating dates from the last rounds of the GATT rounds, and I think reached its peak probably in the conclusion of the Uruguay round that created the WTO, and that system provides for a basket approach. So there's a defined work program that defines all the negotiating areas, and the commitment is that all of these issues will be decided together by consensus. That forces, of course, compromises between the different negotiating aspects. And it works very well as long as each of the negotiating parties finds something in the basket that is sufficiently interesting and sufficiently motivating for the country to make compromises on the other issues. That was spectacularly successful during the Uruguay round, which founded the WTO, which has added new disciplines to the multilateral trading system, as you know, TRIPS, SPS, phytosanitary measures, trade labeling, TBT, other areas. It has made members give up parts of their sovereignty under the dispute settlement system, which they probably wouldn't give up anymore if you asked them today. So that has worked very well. Arguably, it's working less well today. The Doha round of negotiations has been stalling for a long time. And they're very, very small steps of progress, only to be seen very intermittently. So it is clear that the structure of having a large basket, hoping that everybody will find something motivational in it in order to move forward, is not currently showing much success. Now, how do you get out of this negotiation? There are obviously two ways and two approaches how to do this. You could reduce the basket, abandon the basket approach, and go back to single-issue negotiations, taking the issues one by one, which is, for the IP perspective, the case in WIPO. Or, of course, you can add additional issues, put more issues into the basket so that there are, again, things that are sufficiently interesting for all members so that they are willing, once again, to look at compromises in areas that are not their priority. There are some that are proposing this. There are a number of issues that were previously taken off the table in the WTO, as you know, competition law, financial services, various other things. There are those proposing to add new issues to the basket, e-commerce regulations and related regulatory aspects, things that one may look at, but this is certainly in flux. Now, from an IP perspective, negotiating within the WTO, I think you can look at two examples. The element of the Doha round that gives a mandate for negotiating IP is the mandate to negotiate a register for geographical indications for wines and spirits. As you know, this is a mandate that stems from the TRIPS agreement. It was part of the consensus and the compromise that was found in the TRIPS agreement, and is now a mandate that is about 20 years old, and is firmly embedded in the single undertaking. So it means its progress and the negotiating strategy with which members approach it is tied to their approach to all the other aspects in the basket, market access, agricultural subsidies, etc., which makes it very difficult, as I've just described. There's another example of quite successful negotiation of IP in the WTO, which is the Public Health Amendment, or the Paragraph 6 Amendment, if you like, which, as you will recall, came from the Doha Declaration on TRIPS and Public Health and mandated members to find a solution to access to medicines problems and certain constraints for members that did not have their own capacity to produce pharmaceuticals to benefit from compulsory licenses and production of pharmaceuticals in other countries. So essentially authorizing compulsory licenses for the export of pharmaceuticals. Now, if you look purely at the negotiating history of that, that was a formidable success. The mandate was defined in 2001 in November. The decision was concluded on the 30th of August of 2003. Now, that's very quick. It resulted in, and it was not an easy negotiation, as you will recall, and as those who've worked on this will know, the overcoming the resistance of the US and the European Union and others in permitting the circulation of compulsory license-produced pharmaceuticals outside the country where they were produced was a major, major obstacle and needed a lot of ingenuity to be overcome, but it was successful. Now, what was the difference to the GI register? Obviously, this issue was not tied to any other issue. It was a single-issue negotiation. It was the mandate for its negotiation was not tied into the single undertaking. It was clearly a very popular issue. It was one with a sufficient degree of urgency attached to it. And it benefited, let's say, from a forum that was used to negotiation and could produce results relatively quickly. Now, finally, and I guess the one that is on most people's minds when they talk about international agreements and IP is free trade agreements and regional trade agreements. And there, I mean, purely from the three aspects that I've been looking at, motivation, forum, and constraints, it is a bit similar to joining the WTO. Your motivation is a mix of objectives. It's not necessarily predominantly IP. It may be predominantly IP for those who seek to increase IP protection standards in their partner countries, but it may not be in those who are on the receiving end and whose great motivation is to secure market access, political closeness, or otherwise association with the partner with which they are negotiating. The scope of these usually, if you look at the vast majority, usually spans many disciplines of trade, ACTA being an exception to this, which was very focused on actual counterfeit trade, as it purported to focus on in its name. But most of the FTAs and the RTAs have a broad scope, so they are similar to WTO accession, because the approach by the country obviously takes an overall approach and needs to get its preferences clear about what type of compromises it is willing to make, which concession it is willing to make, in what area, and at what cost. The forum, of course, differs quite significantly from the fora that we've described because it's perfectly self-defined. The way you negotiate FTAs or RTAs usually takes place in rounds where the parties have a lot of control over the frequency, the modalities of negotiation, the degree of transparency, and the degree of participation that they are willing to offer or to apply. Now, the constraints, of course, for, let's say, the IP part of the negotiating team is again similar to the WTO. You may only be negotiating one part of the agreement. Your concerns will have to be weighed against concerns in other areas of market access or regulatory concern, and you may well be trumped by the head negotiator at the end of the day that says extending the term of copyright protection to 100 years is less of a concession than foregoing market access in fisheries or in beef or in financial services. In terms of forum, the dispute settlement question that I've mentioned as a difference between WIPO and WTO is here more complicated. If you've looked at the RTAs recently, particularly the TPP, there are indications of establishing separate dispute settlement mechanisms, which throws up other questions. And then, of course, there is the famous WTO MFN provision, which you're all familiar with, the most favored nation obligation, which in the TRIPS area has very few exceptions. That is something that is not often thought about. But it means that, of course, substantive provisions that you agree to in the area of intellectual property in bilateral agreements become WTO obligations, because there's no exception to the MFN clause as there is in the area of trading goods and trade in services. That's not so much a problem because mostly intellectual property obligations are implemented in a non-discriminatory fashion anyway in your domestic legislation. But it means, of course, that the concession that you're making in a negotiation, if you cannot limit its effect to just your negotiating partner, let's say extending the terms of copyright to 100 years only for the works that come from that negotiating partner, it has to apply to all WTO members. That means the value of that concession is, of course, quite different than a concession in market access, which you can clearly target and limit to only one country. Let me close with just two thoughts. I think looking at these different constellations highlights a little bit I think the preferences for fora of negotiating countries, so where they prefer to negotiate something, whether it is attached to a dispute settlement system or not, and whether they want to have more or less control over the transparency in it. And it says something about the relative ranking of IP in the country's preference structure when they are approaching mixed objectives agreements. In terms of success, I think well, maybe we can discuss that in the questions, whether single issue popular issues are more successful than others. But just one last word about what happens once you conclude, because I mean we've seen, despite all these problems, quite some conclusions of treaties, be they bilateral or individual. People have not thought that much about the struggle for ratification. We know that ratification is becoming a much bigger problem than it was. Treaties used to be ratified relatively quickly. It is now takes much more time. If you look at the Beijing Treaty of Audiovisual Performances that was concluded in 2012, it's still not ratified by more than 12 people, 12 signatories, and so it's not enforced. Marrakesh Treaty, being the most successful one, is now finally entering into force at the end of this month after the 20th member, Canada, has deposited. So I think these are more observations than clear identified problems, but I think they describe some of the challenges. From the multilateral systems point of view, the concerns that we have are mostly related to coherence. And I think being amongst academics, I think if one can encourage research in this area, particularly on the role of MFN in the cohesion of multilateral treaties and in IP treaties and what they mean for the obligations of individual countries, and the interaction of different competing or overlapping dispute settlement systems, I think these will be the concerns for the future.